easement agreement dated July 22nd, 2021 for the holding tank on the property located at 4042 Finley Arena Road, which outlines tank closing and cleanup procedures.
I'd like to make a motion to approve the addendum to the temporary easement on 4042 Finley El Rama Road.
I'll second.
Okay, Supervisor Lawson, motion. Supervisor Trax, second. Is there any discussion?
I'm looking for mine because I didn't get it until, after the board packets came out. I wanted to ask a question of Sarah Scott. So in this addendum, if I recall, let me see what's in my packet. It says about going and, there it is. About putting in, having it engineered and putting in a stormwater drain on the property in question. I've never, and I don't know what the law is, but I have a problem with spending taxpayer money on a private property problem. I understand the current problem that's going on and that seems to be a public safety health issue. But the addendum has to do with fixing a stormwater problem after that problem is fixed.
So for clarification purposes, I'm not an engineer, so I do not want to speak on the engineering portions of it. I will refer that to Mr. Odell. However, this is policy and procedure for cleanup of a holding tank pursuant to the Pennsylvania Department of Environmental Protection. There are certain rules that every township has to follow according to the PADEP. You can't have raw sewage running off the property, which is why the holding tank is there. This is quite a standard agreement. It's simply to protect the township and to protect all the residents and property owners from hazardous sewage, hazardous waste.
So I understand that part, that was the original easement agreement.
Correct,
The
and that
addendum.
expired in July, is set to expire July of 2022.
But we're voting on the addendum.
Correct, which is on the cleanup procedures that are pursuant to the rules of the PADEP.
Okay, cause why wasn't that in the first one then?
It was in the first one, but there wasn't cleanup procedures because we were not sure when an end date was in mind. We're, again, not sure when an end date is in mind as well, as you are aware, however.
But this isn't a new easement agreement, this is a addendum to the original agreement.
Correct, and the original agreement will just go month to month when it's set to expire pursuant to however long the holding tank is necessary for public health and welfare and safety of the property.
So
So it's not a brand new agreement, it's just some additional provisions that were already agreed upon before, some additional provisions that will be agreed upon for the future. So that the property can be cleaned up pursuant to DEP requirements.
So the problem I have partially is with number 7 on the agreement. The problem that I had has to do with okay, so I get keeping the French drain that's there. But having Harshman install another drain leading to the French drain that's there to collect stormwater and groundwater.
Sean, can you speak on this, because I'm not an engineer and I don't know the policies and procedures behind stormwater and
Sure.
drought.
So the way the property is currently set up, there's a French drain collecting the sewage, and that runs under a driveway that had to be ripped up and repaved, and then it goes to a holding tank. So the question is, what happens once there's no more sewage there? So the simplest to think about option is just remove everything the township put in. But then you need to tear up the driveway, you need to tear up the yard, you need to repave the driveway to make the property owner whole again. My understanding is the property owner was okay with basically basically abandoning the holding tank and, just filling it up with stone, crushing the lid, and then basically what happens is you'd have a drain just in the ground. So basically it's just extending that drain to the low-lying area so it can French drain, normal storm water. So rather than take everything out and repave the driveway, it seemed to be a lot cheaper on the township's expense just to extend the drain, 20 feet, 10 feet, whatever it is, so it can drain to the natural drainage course.
See, I wasn't a supervisor when the whole thing started, I was in the audience, but my concern is, it is surchargeable to a supervisor if we are doing in excess work or something to a private property with public money. And that was my concern with I get that there was a public health and safety problem. Not saying anything about what was done already. But unless there's a public health and safety problem, or we are the ones putting the water there, we don't have a right to spend public funds to correct it. So I was just trying to make sure, and I'm not that privy to all the information, so that was my concern.
Supervisor Dupree, if I may add to, most temporary, permanent, any easement agreement states that all land shall be restored back to its original form, whether that be grass, whether that be seeds.
And I get
Most easement agreements would agree that if the township messed up your property, they're required to fix it back to its original content. And I think that's the purpose here, is to make sure that this property is back to what better than what it was before, so that this property owner no longer has raw sewage on his property.
And this is just an addendum to the original.
Correct.
If that be the case, I don't know why it wasn't in the original.
I did not do the original agreement, I can't speak for anybody else, all I know is that the addendum is here to ensure that the property owner is satisfied and that all parties agree.
Sarah, do you feel confident that Ms. Dupree's statement that the board will be surcharged or could be surcharged based on?
I don't know that personally, that is something that I would definitely have to look into, so I can't give you an exact answer. I would be more than happy to look into that, but from my recollection, no. But again, that's not something that I know off the top of my head. That's not
So
something I've
Sweat
heard
Law
before.
has prepared this?
Correct,
Okay, with Harshman.
correct.
So would you have prepared something and put it in front of the board that
No,
and
I would
advised
not.
us something that we could be surcharged?
No, I would not. My office would not have done that.
Are we trying to restore a property owner's land who lent us his property to mitigate raw sewage
That's correct.
on Finley El Ramo Road, which
That's
is a
correct.
public health crisis?
Correct.
Is it our obligation to restore the land?
It is our obligation as a township and as the person who was using the temporary easement. It is our obligation to restore the property back to its original content.
And, you know, I just will have one comment. Are we still in discussion period? Okay. You are, Bobby?
Yes.
Okay. Based on what was just stated, that could happen, another surcharge, comment, it's the second we've heard in a couple months from various people. I would be comfortable with adding a contingency on that motion that was made. And this, it would be to have Sweat Law Office, check on the surcharge possibility, that be a contingency on this agreement. And obviously, if there's no problem, it goes forward, but if there is a problem with surchargeable, then.
You can definitely add that. Again, my office would not have prepared something that I believe that would be surcharged for. However, if that makes you feel most comfortable.
Well, this is the problem. I mean, we get comments on bills and engineering and legal bills specifically. And this is an area where if someone makes a statement like that and it purports that board, or whoever agrees with this motion, could be surcharged. So then, we're forced to ask you for more legal advice, and this is how bills keep accruing. But I don't know how to solve that problem.
I question the thought process of sweat law to make a easement agreement that needed an addendum. That would have cost more money. If it's the same thing, why wasn't all this stuff put in the original easement agreement? But that's what caused the question of mine. What's different of what's changing here? Why this wasn't, it's bringing Mr. Barna back to whole and solving the public health crisis. What needed the addendum?
The agreement was silent on cleanup policies and procedures.
Which is more costly in the end to do two agreements than one. But that's what caused the question of mine, of,
Rick,
I'd like to add a comment. We're talking about costs and cleanup. We put a holding tank in front of somebody's yard. We're very fortunate he agreed to do it. This township's very fortunate that we didn't get a DEP fine for raw sewage on the ground. We saved money by correcting this problem temporarily.
Is there pictures of that toilet paper?
We owe the resident to remove it, clean that place up 110% and do it the legal way with the engineering's advice, sweat law office advice. There should be no discussion. We should be very happy that he's gonna agree that this tank deal is still gonna be on his property probably for another 6 months. I'm very thankful for him that we were able to work with him. That's all I have to say.
I can only speculate when, I know Mr. Lawson and Sean and Jamie, Dave, Eskin, were all up at Mr. Barna's property with him for days when the original construction happened. That emergency meeting we had, and when it was unearthed, the big pipe that was filled, compacted, all that you uncovered and dealt with, and I know there was an emergency easement agreement within those emergency meetings. I would speculate, and you can maybe add, that the board at the time and the people solving that emergency problem wasn't thinking on restoration. You were probably, your mind was in the immediate emergency. Would you speak to that, Sean? Was that something you were thinking?
Yeah, I mean, even to begin with, we didn't know what the issue exactly was that we were uncovering, so. I can't really recall. I remember everything was very fast when it was happening, the thought process put into the restoration, but I imagine if, at the time, the thought would be, well, let's put this in and then let's take it out and make this property whole again, and my understanding is the property owner is okay with this plan, and this plan's gonna be, cheaper than if we actually took everything back out and put his property back the way it was. The way it's gonna be remediated is gonna be, to DEP standards, and it's gonna cost the township a lot less than taking that tank out, filling the hole back in with dirt, chasing that storm line all the way, removing it, ripping up the driveway, repairing it, section of pipe and truckload of stone to fill the tank up and crush it, and it's gonna be the cheaper option, so.
Madam Chairman, you brought something to my attention. That project was shovel-ready back then when we came up with the idea of putting that tank in Mr. Barna's. This project should be done right now. Had we not been fought in a lawsuit that the public complains about by Peters Creek stopping us from putting it in. This project should be totally done. And we're still fighting them to put it in to get sewage off the ground.
So, Attorney Scott, do you suggest that the board adds anything in there, are you comfortable that we're not going to be surcharged? Would you have produced this addendum if you thought that we would be surcharged for it?
I would not have produced this addendum if you would be surcharged for it. I believe that it is our legal opinion of our office that we would have you approve the agreement as is and the motion.
Okay. Any other discussion on item 22? There was a motion by Lawson, second by Trax. No more discussion? Roll call vote, please.
Mr. Trax?
Yes.
Ms. Dare?
Yes.
Mr. Lawson?
Yes.
Ms. Dupree?
I'm gonna abstain just because I wasn't part of the initial, that were addendum, we have an addendum too, so,